As part of its ongoing role in support of the judicial network in Central and Eastern Europe, the Seeley Institute presents a series of seminars on remote judging, where we discuss and suggest best practices to guide judges as they come to grips with e-justice, fair trial rights and international standards.
Hello everyone, welcome back to another live session. This evening, as you know, we're going to be looking at the sort of practicalities, the technical challenges, which I think we've faced already in just getting onto this Zoom call, of using IT in remote judging. So broader than just remote hearings, but also case management, keeping evidence, storage, and so on. All of the things that, as Frida's saying, you've been discussing on the forum in the last couple of weeks, which has been fascinating. So thank you for all your contributions. I've sent a summary of those to our two speakers, who I'll introduce shortly. And just to explain how the next 2 hours will play. So we'll have the first hour where we'll hear from our two speakers, and then there'll be opportunity for question and answers. Then we'll have a short break, and then we'll come back and pick up on some of those issues and some of the things that have come out of the discussion forum, so we can have more of an in-depth debate on those issues. As I've suggested before, what I'm doing is I'm pulling out from the discussion forum and from these live sessions examples of good practice and ideas, so we can then put them together in a sort of repository for you at the end of the course. So if you haven't seen that yet, it's just because it's work in progress and we're just trying to find the best way of presenting that information to you. But all of the rich insights and examples that you're giving are not forgotten, and I'm collating them so you've got them in an easily accessible form at the end of the course. So for this first session, we have a panel, and I'm delighted to introduce them to you. So we have Professor Marek Świerczynski. I'm attempting probably extremely badly to say your name. He's a professor at the University of Warsaw and attorney at law. He's been consultant to the Council of Europe on electronic evidence and the digitization of the judiciary, and is chairman of the Artificial Intelligence Law Team. He's prepared the Council of Europe guidelines, which we sent you the link for, regarding electronic evidence that were adopted by the Committee of Ministers in 2019, and the next guidelines on digitalization of the courts, which have just been adopted. We're also joined by Professor Jacek Golesinski. Again, apologies for the pronunciation. Who's Vice President of a regional court in Poland and president of a team established by the Ministry of Justice on informatization of court procedures and on electronic mandatory procedure. He's also founder and director of the Research Centre for Legal and Economic Issues of Electronic Communication. So I can't think of any two people better placed to speak to you on the issues that we're talking about tonight. So I'm going to hand over to them for their presentations. And there'll be an opportunity after they've spoken for question and answers. If you want to raise any questions in the chat function as they're talking, please feel free to do so. And I'll collate those, and then we can, if there's a lot of them, we can just manage them at the end of the presentations, or we'll have an opportunity for you to ask questions as well by raising hands. So I'm going to pass over to Professor Marek initially for your presentation.
Thank you very much, Rachel. And indeed, I will start with my presentation because Jacek is not ready yet. He still has some technical problems with the connection because he tried too many times and he was blocked for some time, but he will reconnect to us and he will present the second presentation. So I'm going to start with the electronic evidence and the very first guidelines that we prepared, discussed, and adopted in the Council of Europe 1 year ago. And it is based indeed on the good practices and good examples from member states of Council of Europe. like Lithuania, for example, Estonia, Germany, also Poland, because we have e-court in Lublin. I prepared a presentation, so I'm now sharing my screen with you. So the Council of Europe, but first, of course, I'm very grateful and thank you for all your questions and inquiries that were collected by and sent to me a couple of days ago. Because indeed you ask about the problems that we discussed and that we tried to regulate in the guidelines on electronic evidence. And by the way, we are now speaking about the electronic evidence in civil and administrative proceedings, because this is the title of the guidelines. As Rachel mentioned 2 weeks ago, there was a plenary session and we adopted the second guidelines on digitalization of courts. Here we use the name of ODR, Online Dispute Resolution, a little bit, I think, confusing, because typically ODR is understood as a variation of ADR, Alternative Dispute Resolution. But Council of Europe is using ODR term in regard to using this, remote judging, the IT tools in traditional proceedings. But of course, this is the second guidelines that will be still to be discussed and presented by, these problems will be presented by Professor Jacek Gołaczyński, but I will stick with the electronic evidence, the first guidelines from 2019. So you asked about authentication, how to authenticate the evidence. Is it the responsibility of the judge or the parties? You indicated the gaps in the legal systems regarding the handling of electronic evidence. You were mentioning different electronic case management systems and how to process the paper evidence and electronic evidence. Maybe sometimes we have a hybrid system. So of course, my intention will be to answer these questions later on the next slides. But in fact, what I'm going to do is to show you the specific guidelines and number of guidelines, but not only the guidelines, but also explanatory memorandum to the guidelines. And this numbers, these points directly try to give the response to your question. So, I understand that we have a little time. My intention is also to encourage you to read these documents, both the guidelines and the explanatory memorandum. Here on this slide, you asked questions regarding the storage and security of electronic evidence. You mentioned that, well, judges may not have enough knowledge and awareness of the specific issues. I will also make a reference to specific points in the guidelines. And cybersecurity, of course, is also an important point. So you can download the guidelines from the Council of Europe webpage. And I will, maybe not now, but I will put this link to the chat box later. And of course, I will send you also this presentation. But this is just a starting point. So takeaway is to really, if you didn't do that before, it will be good opportunity to open this web page and download not only the guidelines, because the intention is that the first document, the guidelines themselves, must be short, must be easy, must be transparent, because the judges do not have time to read very long documents. But in the explanatory memorandum, you have all these examples in the box. You have the specific judgments from different member states, like from Croatia, what to do with texting SMSs as electronic evidence, what value it has, or maybe do we should request always or expect that the evidence will include the qualified electronic signature? Maybe not, because it's not a very popular tool. But what to do with other types of electronic signatures and other methods of authentication? Official language versions. This is an English version and French version. So whatever you prefer, you can use one or another. But as you see, we also have an unofficial translation into Polish and into Russian. So maybe it will also useful in your practice. Some background documents, studies, reports, data collected from member states can be also useful. We have some also publications, and because I understand that most of you are from Czech Republic, comes from Czech Republic. This is Czech project. So the latest paper was published in Masaryk University Journal of Law and Technology. I hope that you attend the cyberspace conference, that international conference that takes place every year in Brno in November. So a couple of weeks ago, we had the last conference. Okay, the scope. The guidelines deal with those aspects: oral evidence taken by a remote link, use of electronic evidence, collection, seizure, and transmission of evidence, relevance, reliability, so the authentication issue is discussed here, storage and preservation, archiving, and the last part that we are executing now, in fact, because the training, this seminar, this session is a part of training and education of not only the judges, but the legal professionals, attorneys at law, and so on. The aim of the guidelines is, of course, to facilitate the use and management of electronic evidence. And to use simple words, you can treat it as a kind of a toolbox, or maybe a checklist of possible solutions that you can use in your practice. We have a definitions, so I will not present you and discuss in details all these definitions, but only just want to underline the most important aspects. Well, electronic evidence, well, probably if you don't have the definition in your legal system, it may be of use. This is a very general definition. But metadata is a very key point of the guidelines. When we started this work 4 years ago, because it takes time, we had many meetings and very deep discussions and redrafting and so on. But the first idea was to say, please be aware of metadata. Please be aware that the original electronic evidence contains some hidden data that can be useful during the proceedings, that can be very important for probative value of the evidence. It will give you information about the author, about the date of creation, the history of evidence, and so on. So even very simple verification, of a document in a Word editor can show you the very basic information about the origin of these documents. And if you request from the parties that the parties will only provide you with paper evidence, with the printouts of, for example, of the web pages, when this metadata can be lost, yes, it will decrease the value of the evidence. So, okay, maybe I'm stating some things in advance because we will discuss it later on the next slides. But in general, this is what I really want to say at the very first point. Remember about the metadata. And then we have also trust services, because if you are asking about the security of information and about verification, authentication of a specific evidence, well, you should be aware of the trust services, of the services that are provided by service providers, not only those who issue certificates to electronic signatures, including qualified electronic signatures, but also those who secure the transmission. Here we should mention, and we mention a lot, many times in the guidelines, how important now our cloud computing services for storage of some data, and also our knowledge of the judges, how the system works. And if you start your adventure with the electronic evidence in the European Union, of course, the eIDAS regulation, EU regulation, will be your very starting point as a provision that deals not only with electronic signatures. So don't be misled that this is only about the electronic signatures. This is about authentication services, different type of the certificates also that can validate the data. And of course, the importance of such documents and such provisions do not cover only the services of EU providers, because, for example, if you take DocuSign, I hope that our colleagues from United States, you know this very big system. So DocuSign is a system for not only for the identification of the author of a specific message, but it is tracking the how the message is transmitted. It is collecting and it is generating a lot of data that can be then used for evidentiary purposes. So this is very important to remember about the eIDAS regulation. Of course, in Council of Europe, we don't. We are not allowed to say too much about eIDAS regulation, because Council of Europe is much bigger than European Union. It covers other countries, so it's not our intention to extend such regulations, for example, to Russia. But still, of course, it is very, very important document, at least for us. So if you are asking, your question about the how to authenticate the evidence, how to check, how to compare it with the original, well, my first, what I will say first is that the electronic evidence will be your original evidence. Yes, the paper printout, for example, will be only derivatory type of the evidence. So what we say also in the guidelines is to allow the parties to provide the evidence in original form. And we also say that, of course, in civil and administrative proceedings, this is a obligation of the party to submit in a secure and proper way, and also to explain how it is secured. But here on this slide, I'm just quoting several guidelines, specific guidelines. But I even start here with the fundamental principles, because maybe I don't know all your intention that stays behind this question. We may still return to it during our Q&A session, but I will first say. And see, this is our first fundamental principle. This is your job as a judge, to decide on the potential probative value of electronic evidence. This is not something that should be delegated to IT experts, but this is what we quite often see in the courts, that there is an expert, and the expert say expert witness, depending on the system, we can call him or her expert witness. He says, well, it it has some value or not. But this is not a job of the expert. This is responsibility of the judge. And of course, in other fundamental principle, we say that there should be neither preference, no discrimination for electronic evidence. It should be treated in principle as any other kind of the evidence, also of the paper evidence. So no discrimination, but also no preference for that. But of course, I think that you are waiting for very practical responses to your questions, and so I tried to quote specific guidelines, but of course it's not possible for me to put everything on this one page. So this is, I hope, only the start for your work, and as a takeaway, you will explore the guidelines and explanatory memorandum. So, for example, in number 7, we say, well, don't expect that you will deal with qualified electronic signatures. If there is a qualified electronic signature, then the life is easy. You know, there is a full system how the qualified electronic signature works, how it is to be verified. We have tools. For 20 years, this system operates. But the reality is, of course, that a very small number of people uses qualified electronic signature. So expect that you will rather deal with simple or maybe advanced kind of electronic signature. And in doing that, when you deal with that, please, you have to be aware of how the trust services works in establishing the reliability of electronic evidence. Well, I'm not promoting here DocuSign, but in fact, a couple of years we did this international review for DocuSign in Baker McKenzie when I was working in Baker McKenzie, and DocuSign published this report on the web pages. So you have for every country, for almost every country in the world, you have information from DocuSign. What is the impact of this system on evidentiary proceedings? What kind of the contracts can be signed with this system, and so on. You can easily find it. I will put a link to the chat box later on, so you can read it. This is also, I think, quite useful takeaway. What we say in guidelines number 21 and 22 go even you know, we try to be as useful as possible for the judges. We say, well, if it's only possible, you should accept the electronic data. You don't need to validate it. You need to specifically verify it. You know, maybe try to even presume, maybe this is not a legal presumption, but presume the reliability of electronic data with, you know, a basic checking of the identity of the author and integrity of the data. If we use this word integrity, we also here referring to the trust services that can ensure the integration of the data. And you don't need to check it, to compare it. This is also a job for the parties. If the other party challenges the electronic evidence, then maybe the other party should explain what is wrong with the electronic evidence and what are specific problems with associated with electronic evidence. We also say in guidelines number 24, if you have an official document from a public authority, in Polish Code of Civil Procedure, we even use the term official documents versus private documents. So there is a presumption of authenticity of public electronic documents in such proceedings. So this is also what we wanted to present here, that it's, you know, you don't always need to suspect that something is wrong with the electronic evidence, that this is different. This is not that you are used to. You should have some basic knowledge, but there should be some trust in such type of evidence. Well, and here we don't have time to discuss all of these aspects, but in explanatory memorandum the language is more extensive, and we give here we give some tips how to establish the identity of the author of electronic data, how the trust services works. We give some examples in the boxes. We explain the role of the certificates to electronic signatures. We say, for example, that the court may request the service provided related to electronic signature or to another service to make a statement in relation to the matters upon which it is competent to provide evidence, and so on and so forth. Here, and here this is the rule that the party seeking to rely on the evidence may be required to demonstrate its authenticity, for example, submitting metadata or seeking an appropriate order to obtain additional data from other persons, such as trust services providers. So, as we are speaking about civil and administrative proceedings, this is responsibility of the
Okay.
And of course, legal professionals should be also trained to do that. Hello, Jacek, I see you. So you are with us. I'm in the middle of my presentation, but I think I should finish it soon to allow you to ask the questions. But just some of the final remarks related to your questions. And of course, most of such issues I already presented before, so this is just a repetition. Because if you say that well, we don't have a uniform system of electronic data management in our member states, well, this is true. I think there is a lesson from pandemic that really member states should establish the procedures about data management and help us. The guidelines can be treated only as some provisional system of it must be general in some way, because it must cover all 47 member states. But some simple statements. Courts should be aware of importance of electronic data submitted by the parties in its original format. This is original. You should not say that original is only a paper version, that the printouts that we typically, what we did always in the past was submitted to the evidence. Maybe I'm not a judge, but I act as an arbitrator in the disputes on domain names, and I'm really surprised that the practice is that everything is printed and the metadata is missing. And what I'm doing in such cases is that I'm checking the internet. I'm looking for the original versions of the web pages and domain names. Even I go to the Internet Archive, because I don't know if you are aware, but we have a specific service that is called internetarchive.org, and you have all history of the web pages of the internet included there. So you can, for example, put the old date from 1 year ago, or even 10 years ago, or maybe even 20 years ago, how it looked like. And you can collect some data, some from the history, and check what information was contained on the internet. So don't request printouts of electronic evidence, because also printouts can be easily manipulated, as they exclude metadata or other hidden data. Sometimes it's even easier to manipulate the paper version of the documents. Well, if you are asking about the knowledge of the judges, that the judges themselves may know very little about where this information is stored and how secure it is, and should they? Well, you should. Of course, you should be aware of it. You should have this knowledge, but of course, I assume that you are participating in this session exactly because you are looking for such kind of the knowledge. But again, you have your knowledge about how it works, but still, if we speak about civil and administrative proceedings and dispute, from the point of view of the guidelines of the Council of Europe, this is parties' obligation to collect and submit data in secure manner to the courts. So we trying to explain it with guidelines number 10, 11, also indicating the importance and the probative value of metadata. And in explanatory memorandum, when we also give some examples from specific countries, how the notary services can be used for storing, collecting, securing the data. So we can reach out to other professionals like the notaries, to not only IT specialists, to secure the data that is going to be submitted and stored in the courts. And of course, we should be aware also of the network-based services, because the more and more data is now stored and collected in the cloud computing, using cloud computing services. Even we speak about blockchain in the guidelines, so how the blockchain can protect the information from any modification, and then in result it can be used as a very reliable evidence in case of the dispute. So specific standards are still missing. I agree with you that we don't have a very good support from the governments in this respect in some countries, because when we discussed this issue 2 weeks ago, Turkey, for example, said, well, we now have a complete digital system established on June, and it works perfectly. Lithuania has a Liteko system that is also a very good practice. But there are some countries, I'm afraid that also now in Poland, we don't have such support from the government, and some standards are still missing regarding the management of electronic evidence. So in the meantime, judges, professionals should seek to ensure the integrity, confidentiality, and security of such data using the standards and the tips, maybe not standards, but rather the tips, the provisions that you can find in our guidelines. Well, some obvious, I think, statements, both paper files and electronic evidence must be stored in secured manner. So we also explain it in detail in the guidelines, number 25, 26, 27. Here in 27, please note the problem of using the proper carriers, the proper methods of the storage of information, because if you are using, well, CD or DVD, then there is a deterioration of such carriers, and the data can be just lost during the process. So still, here we maybe even promote the other places of data storage, like the cloud computing system that's now developing very fast, and that, of course, we should adopt a very proactive approach to protecting the integrity of electronic evidence from cyber threats and unauthorized access. So, I understand that my time is over. Jacek is with us, and Jacek will present his second part, but I will share with you those links that I promised to put in the box. And here you have also my email address, and I'm waiting for the Q&A session. Thank you very much.
Thank you so much, Professor Marek, for that extremely insightful presentation and for tailoring it to the issues that arose on the discussion forum. It's extremely helpful, and to talk through the guidelines. I'm going to pass straight over now to Professor Jacek, who I hope has just joined us. Hi, welcome. We did introductions at the beginning, so I'm going to pass swiftly over to you for your presentation, and then we'll give everyone a chance. I'm picking up the chat questions, So we'll get everyone a chance to get back to those at the end. Over to you.
Okay, thank you very much, Professor. It's very nice for me to participate in this meeting. I'm interested of problematic of informatization of justice from several years. I'm a professor of Wrocław University, but also judge of appeal court in Wrocław, and many years I'm interested in informatization of common courts of justice in Poland, because I was responsible for this area in our government, because I'm a former vice minister responsible for informatization of Polish courts. But now I'm still only judge, and I can use this informatization tools in practice in my work. So I can show you a small review about the informatization of civil proceedings in the time of COVID-19 pandemic on the example of Poland. So I make presentation about the only electronic pleadings, the electronic service, and the remote public hearings. So only 3 subjects I would like to show you. And on the 3 points. First, before the COVID-19 pandemic. Second is during the COVID pandemic. And next, the conclusion and postulates the lege ferenda, what we can have do in the future in this area. So electronic pleadings appeared in the Polish Code of Civil Procedure by the Amending Act of January 2009, which introduced electronic proceedings by the electronic order of payment. The Act of 10th July 2015 changed the way of submitting pleadings and signing them. It means that our Article 125, Paragraph 2, Code of Civil Procedure, now state if a specific regulation so provides, or if a party decides to file pleadings via the ICT system, pleadings shall only be filed via the ICT system. Pleadings that are not filed via the ICT system do not produce legal effects, which the law provides for the filing of the pleading with the court. Thereof, the court shall advise a person that files the pleading. The Article 20 of the Act of July 2015 states that within 3 years since to entry into force of the Act of July 2015, the choice of submitting pleadings via the ICT system that supports court proceedings and further submitting pleadings via the ICT system that supports court proceeding and further submission of these pleadings via this system is allowed if is it possible for technical reason attributable to the court. Therefore, the ICT system operating the court proceedings should have been established until 8 September 2019, but unfortunately that's not happened because the ICT system to support court proceedings has not been established. The Article 20 was replaced by the Article 6 of Act of July 2019. In place of this regulation, the legislator adopted the new writing of the provision. It means now the Article 125, Paragraph 2, Code of Civil Procedure state that choice of submitting pleadings via the ICT system and further submitting of these writings via this system is permitted if it's possible for technical reason attributable to the court. It means, unfortunately, that it depends if the system will start of the technical reasons attributable to the court. And in Poland, the Ministry of Justice is responsible for creating, for establish this ICT system. And unfortunately, now there are not plans to improve to our courts this system. The second time is electronic service. Was also introduced to the Code of Civil Procedure along with electronic proceeding by the electronic order of the payment. The Act of January 2015, amending the Code of Civil Procedure, extended the possibility of using electronic service in the other types of court proceedings. The new wording of the provision of Article 131 Code of Civil Procedure introduced by the Act of 10 July 2015. The addressee who has chosen to submit pleadings via the ICT system may resign also from electronic services. So now we have a situation that electronic service may occur first when a party has chosen to submit pleadings, and secondly, when a part is required to submit pleadings only via the ICT system. In specific regulation, the provision we have Article 131 Code of Civil Procedure, and this article states that the court shall serve documents via the ICT system. It means electronic service, if the addressee has filed a pleading via the ICT system or has elected to file pleadings via the ICT system. With respect to electronic service, a pleading shall be deemed duly served at the time stated in electronic confirmation of receipt. And failing such confirmation, electronic service shall be deemed effected after the expire of 14 days of the pleadings being entered in the ICT system. So this act automatically after 14 days, we know that the service is affected. And finally, Article 140 Code of Civil Procedure states the document generated from the ICT system may be delivered instead of a copy of the pleading of judgment as long as it bears features which allow for the existence and content of the pleading of judgment be verified in the ICT system. In the case of electronic services, pleadings and judgment have the form of document containing data generating from the ICT system. So receipt of pleadings shall be acknowledged in writing by the recipient or via ICT system on the postal operator referred in other article of our Code of Civil Procedure. It means Article 131, or by a document generated from the ICT system. On November 2012, the President of Republic of Poland signed the new Act of 18 November 2020 on electronic delivery. The Act imposes an obligation on public entities to deliver correspondence using the public registered service on electronic delivery in contact with no public entities which have addresses for electronic delivery entered into the database of electronic addresses. The Act provides for the establishment of a new public register, database of electronic addresses, designed to disclose the address for electronic services of entities using such services. The intertemporal regulation provides, among other, by 30 September 2029, both electronic delivery boxes, so far operating by another system existing our public administration in Poland. We called it PUAP. And new delivery boxes of public entities will be used. The Act will enter into the force in principle 1st July 2021. Nevertheless, on the 1st October 2021, regulations obliging professional proxies as well as entrepreneurs entered into the National Code Register. It means, for example, companies, to have an address for electronic deliveries will be in force. But in addition, it is foreseen that the provision of the Act concerning the obligation to deliver correspondence using the public registered service or electronic delivery or the public hybrid service will be applied by courts, tribunals, bailiffs, prosecutions, law enforcement agencies, and the prison service on 1st October 2029. So very long vacatio legis, unfortunately. And electronic pleadings and electronic service during the COVID-19 pandemic. So some courts in Poland allow various possibilities of submitting pleadings, especially secured registry offices, dedicated mailboxes. But there are not uniform regulation on the national scale. Propositions of the regulation of so-called anti-crisis shield 3.0, our parliament our parliament suggests to make the ability to perform services via a special way called ePUAP. It means the public administration ICT system, also via information portal of Common Courts of Justice. And secondly, the date indicated in the confirmation received by the court was to be considered the date of service of the pleadings, but in the absence of confirmation, the pleadings is deemed to be served within 14 days of its sending of submitting to the information portal of Common Courts of Justice. But unfortunately, this regulation was removed from the draft in my opinion, at the loss for citizen. Remote open hearing, this last part of my presentation. So the possibility of holding the remote open hearing was introduced by the amendment of Code of Civil Procedure of 10 July 2015. We have the article 151, paragraph 2, Code of Civil Procedure. And this article states that presiding judge may order to public hearing to be held with the use of technical devices that make it possible to hold such a hearing at the distance. In such case, the participants may attend to hearing while being personally present in another courthouse and taking procedural actions. Procedural actions shall be transmitted from the courtroom of the court to the place where the participants are present and from the place where the participants are present to the courtroom of the hearing court. The participant may take part in the court hearing from the building of another court and perform procedural action there. And the second remarks that decision of the president judge was not subject to any statutory criteria. The current provision of Code of Civil Procedure provide for possibility of performing certain court actions outside the court building. For example, when it's necessary to interrogate a person suffering from an illness or disability, then the interrogation takes place in the place of stay of this person. Or when it is necessary to inspect the object that cannot be delivered to seat of the court, for example, to examination of property. Article 151, paragraph 2, Code of Civil Procedure refers to the regulation of remote evidence, because according to Polish Article 235, paragraph 2, Code of Civil Procedure, if the nature of evidence so permits, the adjudicating court may decide that evidence be taken remotely using technical devices that allow for this to be done. So this provision was introduced to Polish Code of Civil Procedure in order to adjust Polish law to regulation number 861 by 2007 on European Parliament and Council establishing a European small claims procedure. Since the Act of 10 July 2015 entered into force on 8 September 2016, no court in Poland has held a remote open hearing, despite the provision of Article 235, paragraph 2 of the Code of Civil Procedure. It means taking evidence at a distance. The obstacle to introduce the localized open hearing into the practice in civil judiciary was simply organizational reason. The application of this provision would require lending a courtroom for the parties and their attorneys in the court building in their place of residence, so that they could connect with the court conducting the proceedings in another city. And now, what happened during the coronavirus pandemic? In Poland, we have a new regulation, the Coronavirus Act, and in this regulation we have special rules. This is Article 15.2 of Coronavirus Act, and this states that President Judge may order a closed hearing if she deems the examination of case necessary and the conduct of the closed hearing required by the law could pose an excessive threat to the health of person participating in it, and it is not possible to conduct it remotely with the simultaneous transmission of image and sound, and neither party has objected to holding a closer hearing within 7 days from the date of service of the notification that the closed hearing will be conducted. This solution is generally contrary to the principle of openness of civil proceeding and to the principle to public examination of the case. But also the Article 15.3 Coronavirus Act state the president of the court may also order that member of the panel, it means the judges, will, with the exception of the president judge and the court referendary, may participate in the hearing by the means of electronic communication, except from the hearing at which the case is being closed. So this provision stipulates that the limitation of simultaneous presence in place and time at an open hearing also affects the adjudicating panel. The other members of the panel will participate in an open hearing via electronic means of communication. It's possible to regular instant messaging service such as Messenger, WhatsApp, email, or phone call. There are not other rules concerning that. So in Polish legal system, now we can organize the remote hearing, public hearing, via internet. It means using the ICT system of communication, and there are not conditions existing in Article 151, Paragraph 2, Code of Civil Proceeding, that the parties has participate in this hearing in other building of court. So now it's possible that parties and attorneys can participate in this hearing also from other places, for example, for houses, offices, and so on. In Poland, we have a special system for a video conference, because I saw also some question concerning the remote hearing. So in the Polish court, common courts of justice, we have only one system for organized remote hearing. It means video conference. This system is established by Ministry of Justice and is make administration by one of Court Appeal in Poland. Specifically is Court of Appeal in Wrocław. In this court exist special units. It's a center of informatization of justice, and this center is responsible to organize video conference for all courts in Poland. This system is safe, is free of cost, also for parties of litigation and also attorneys. So it's very simple, because the court which organize the public hearing send via email link, and the parties and his attorneys can join via this link to court hearing. And we have also possible to make e-protocol, electronic protocol. So we record all hearings organized via video conference, because maybe you know, in Poland we have a special method of record of the hearing. This is electronic protocol. We call it electronic protocol. And it's possible to use the electronic protocol also during the video conference organized via our central system. So it's not possible, it's forbidden to use other system for video conference. It means Jitsi, Zoom, MS Teams, WebEx, Cisco, Waber, Skype. It's not allowed, it's not possible. But if, for example, judges want to discuss about the judgment, So it's possible to use Jitsi, because our Center of Informatization of Justice in Wrocław organize this Jitsi safety for all judges who want to use this system to communicate, to discuss about such a case. So this problem you mentioned in Poland doesn't exist because we have only one system for all Court of Justice in Poland. Unfortunately, this system is not big, because this system exists before COVID pandemic. So during COVID pandemic, the Ministry of Justice give money to enlarge this system because a lot of courts start to use this system in their work to organize the opening courts hearing. We have only another problem, a problem connected with the principle of public hearing, because in this video conference can participate only parties, attorneys, judges, and where the public who can join to hearing if the hearing are organized normally. Yes. So the Center of Informatization of Justice in Wrocław start to prepare the streaming of such a hearing. The streaming is possible, but we also have some rules. For example, not all cases are open for public. For example, in familial cases is closed. So this system is not a technical problem, but more legal problem, because they are necessary to organize some rules about possibility to use streaming by such a persons. So we started and we discussed it. Last time I participated in the conference in Poland, organized by Association of Civil Procedure Law in Poland, and the very huge discussion started about the make in this time of pandemic 19 coronavirus, the rules of publicity of the hearing. So this is very important text, because it's the one of most important principle of civil procedure. So thank you very much. If you have questions, so.
Thank you so much, Professor Jacek, for the extremely rich and detailed information you've given on the Polish system. Just to remind everybody, this is all recorded, so if you want to go back and listen to any of that, then that'll be available for you. I've seen some very interesting discussions on the chat function. I think there's been a sort of conversation going backwards and forwards, but one of the things just to pick out of that that appears to be relevant to a lot of the questions is around the responsibility of the judge in determining the authenticity of evidence, and how far the judge needs to go, particularly if the parties don't question the authenticity. And there seems to be some, not necessarily disagreement, but some questioning around exactly how far the judge does need to go around these issues. So I'm maybe just ask Professor Marek and Professor Jacek if they had any comments on that particularly, and then I'll go back and see if there's any additional ones that people want to flag up.
Thank you for this question, and indeed we see a lot of comments and discussions on the chat book, and the different experiences from particular countries. and different approach if we speak about the civil or criminal procedure, because the approach can be different. But indeed, when we were drafting the guidelines in the Council of Europe, I had in the mind the very recent example of the behavior of the Polish judge who spent a lot of time on verification of a qualified electronic signature. And it was a proof of a wasted time, because you have a whole system that you really secure the qualified signature. The only thing that you should check is to open the web page. You have a public registers, public information. You wrote that you have this public registers, not only from the public authorities, but also from the trust services providers, when you can easily, spending 2 minutes, check, for example, that a specific qualified certificate is put on the list, and you don't really need to validate it, discuss it with the parties, request the experts. So this was a completely wasted time, and also this encouraged us in the Council of Europe to say that maybe the judge should be more passive here, or maybe more neutral, not to analyze the electronic evidence as something strange and as something dangerous, as something that needs a special examination, but rather to treat it as a standard type of the evidence, and exactly as you also wrote in the box, only try to verify the authentication if the other party challenges the evidence. Sorry for my dogs. Probably you hear the barks of my dogs. So this is one thing, not to be rather passive in this respect, especially in civil and administrative proceedings. We have also another interesting case. Jacek, probably you remember that everyone was laughing on the internet because the judge requested the witness expert only because the evidence was an email. This was an email, so even not an electronic email, but a printed email. So, really, we should not do such things in 2020 and in 2021 soon. Another thing is we had a discussion with Dusan here. Thank you for your firm statement that we are lawyers, we are not IT experts, we were studying law, we hate math, and so on. But and I quoted the guideline on an active management. I think this specific guideline was proposed by our colleagues from Ireland and UK. Where they give this perspective of UK judge who is really owner of the proceedings and can say that this is electronic evidence. It's easy to generate a lot of electronic evidence, but you have to be more specific. You have to give me only something that is relevant to the case. So that's why we try to streamline this activity of the judge and put the specific guideline regarding the judge activity, regarding the checking how to manage the electronic evidence in practice.
Thank you so much. Professor Jacek, any questions?
Yeah, thank you. The electronic evidence now in Polish civil procedure is a problem with experts, because only expert can help to judge to examine some evidence existing only in electronic means. But we have also for example, emails printed and put to the act of the litigation. So the judges start to think about this evidence like paper evidence. But originally, this evidence is electronic, yeah, but it's only printed and put to the act of the case, to the file of the case. So such a judges thinks traditionally and thinks that yes, of course, this paper, it means is written document, not electronic document, but this document exists without sign, yeah, only electronic sign. For example, Jacek Gołaczyński and that's all, yes, or email, my email, yes. That's why in Polish civil code, the Polish legislator established a new form of legal acts. It means the document form. The form is very interesting because it's created on the base of German form, the same form. It's possible to use this form of legal acts without the writing, so without the signed. If it's possible to recognize the author of this will, yeah, for example, or other information if in this document, so we know that this is document created by the party. So it's possible also email. It's also SMS, short messages, yes, via WhatsApp and so on. Never mind. And we can next print it. And if other party don't say it's not true, it's fake, yeah, it's not really, yeah, my opposite created, yeah, especially for this case, so court have to accept these documents because in the new definition of documents in Polish code, civil code, these documents are also documents similar to writing, paper documents. So the problem with electronic evidence become only in this situation when the court have to examine the origin of this evidence. It means find some document existing only electronically. And unfortunately, in this case, it's necessary to ask expert to examination of this evidence.
Thank you so much to our two speakers for all your time. I'm conscious that we have gone over the hour, but I think the presentations were so detailed, I didn't want to stop you, and the chat debate was extremely helpful. That'll all be saved, so we have that information there. Just to say thank you again very much to our two speakers for their valuable insight. Thank you again.